morning. Good morning, everybody, and welcome. My name is Pippa Browdy, and I'm an assistant professor at the University of Montana School of Law. Thank you all for joining us this morning to hear oral argument before the Montana Supreme Court in Montana Department of Revenue versus Priceline.com. I also would like to thank the Supreme Court of Montana for traveling here to hold argument in this case. We are honored to have you, and we appreciate your time. The parties in this case are the State of Montana Department of Revenue and a number of online travel companies, including Priceline.com, TravelWeb, Trip Network, Orbitz, Expedia, Hotels.com, Hotwire, Travelocity, and Sites59. This case involves the State of Montana's sales and use tax for hotels and rental cars. I'm introducing the case today because I teach courses in tax law, and this is a dispute involving the tax laws of the State of Montana. I will be previewing the arguments of the parties, but before I do so, let me first introduce the courts and the judicial process. This morning, we will be watching our state's highest court in action, the Montana Supreme Court. In Montana, we have three major court systems. We have federal courts, state courts, and tribal courts. Today, we're most concerned with the state courts, but I'm also going to give a little background on the federal and tribal court systems. Within each system, the courts are divided into trial-level courts and appellate courts. Trial courts hear and resolve disputes. In trial courts, parties, with the help of lawyers, present facts or evidence through witnesses and documents. Lawyers then make legal arguments as to why they should win. The judges, aided by juries to determine facts, will make decisions at the trial level, and the judge will write out the decision and reason for the decision in an order and judgment. If a party losing at trial disagrees with the decision, they may appeal the case to an appellate court. In an appeal, the parties are usually bound by the facts and evidence presented at the trial level. Parties on appeal make a written argument, referred to as a brief, and they submit those written arguments to the appellate court. As I said, we have federal courts in Montana. Federal courts generally hear cases that arise under federal law, such as the United States Constitution or, for example, federal tax law. The federal trial-level courts are called magistrate and district courts, and we have 6 federal judges in Montana and 5 magistrate judges, a number of whom work or sit in Missoula. At the appellate level, the federal courts are comprised of courts of appeals and the United States Supreme Court. The federal courts of appeals hear cases from the district courts. The United States is divided up into 13 circuits, each with its own court of appeals. Montana is in the 9th Circuit, so cases from the federal district court in Montana are appealable to the 9th Circuit Court of Appeals. The United States Supreme Court is the ultimate appellate court in the country. It hears appeals from both the federal appellate courts and the state Supreme Court decisions that deal with United States constitutional issues. With respect to the tribal courts in Montana, we have 7 tribal nations in our state, and each has its own tribal court system. The nature of a judicial system within a tribe varies. Some tribes have courts that are very similar to state or federal court systems, while other tribes may rely on more traditional tribal approaches to dispute resolution. The case we're hearing today arises out of the state court system. Montana's state court system is similar to the federal system in that there are trial courts and an appellate court. The trial courts in Montana are divided into specialty courts, such as workers' compensation courts, water courts, and limited jurisdiction courts. Limited jurisdiction courts hear cases involving smaller disputes, such as small claims, misdemeanor, and traffic cases. The general trial courts are district courts in Montana. Montana has 56 counties, and they're divided into 12 judicial districts with 42 district court judges. The case we will hear today arose out of the 1st Judicial District in Lewis and Clark County, where Helena is located. Even though the judicial branch of government is the focus of our attention today, the case you're about to hear actually involves all 3 branches of our state government. The legislative branch enacted the laws or statutes that impose tax on certain types of business transactions. The executive branch, through the executive agency, the Department of Revenue, implements and enforces the law. The Department of Revenue takes the position that some of the laws enacted by the legislature apply to the online travel companies. The Department of Revenue is thus trying to enforce the law. Finally, we have the judicial branch. The judicial branch is tasked with interpreting the law. The court's job is to determine how the law applies in this case. Before I get to the arguments that the parties are likely to make today, let me first explain the problem and the nature of the dispute. I'm going to give you an example. These are just hypotheticals solely to illustrate what the case is about. I'm also going to explain some terms or define some terms that you may hear the parties use today. So let's assume that a hotel room costs $100. This is called the retail rate. The tax rate is 10% of the cost of the hotel room, for illustration purposes only. If a traveler goes to a hotel's website and books the room for $100, the law will impose a tax of 10%. 10% of $100 is $10. So the hotel charges $100 for the room and collects $10 in tax. The traveler is the taxpayer. The hotel is said to hold the tax in trust for the state. The hotel then will later send the $10 in tax to the state of Montana. The traveler could also book online through an online travel company. Because of competition and market forces, the traveler will usually pay the exact same total amount to an online travel company as if she books directly with the hotel. So our traveler who books the hotel through an online travel company will pay $110 for the same room. What's the difference? The difference is what happens to the $110 that the traveler pays. Online travel companies are businesses, and they make their money as businesses by negotiating with the hotel for a lower rate on the room. So the online travel company will give some of the $110 to the hotel for the room, and the online travel company will keep some of the money for its services. Back to some concrete numbers to illustrate. Let's assume that the online travel companies negotiate a 20% discount on the retail rate of the room. The discount is referred to as the net rate or wholesale rate, as opposed to the retail rate. If the online travel company negotiates a 20% discount on a $100 retail cost of a room, that's a $20 discount. And so to the online travel company, the room costs $80. $80 is the net rate or wholesale rate. Then there's the tax, a 10% tax based on the rate of the room. The net rate of the room was $80. So 10% of $80 is $8. Recall that our traveler has paid the online travel company $110. Of that $110, we've got $80 for the room, $8 for the tax. The online travel company will pass along the $80 and the $8 of tax to the hotel. That leaves $22 remaining from the original $110. The online travel company keeps the $22 as a service fee, often referred to as a markup or a margin. Again, you might be thinking, what's the difference? There isn't a difference to the traveler directly. You can see from the hypothetical that the same traveler spends $110 on the room, whether she books directly with the hotel or through an online travel company. The difference is how much tax the state collects. If the traveler books directly with the hotel, the state collects $10 of tax. Whereas if the traveler books through the online travel company, the state gets only $8 in tax. The entire dispute in this case is about that $2 difference in tax. You might be thinking to yourself, what's the big deal? It's only $2. Well, as you might imagine, $2 difference starts to add up. So that's the big picture of this case. Remember, my example was just an illustration. The percentages and rates are a bit more complicated in real life. The general background on the dispute is that the Department of Revenue wants to collect that $2 difference. They want the online travel companies to collect the amount of tax based on the total amount the traveler pays for the room, not based on the lower net rate that the online travel company has negotiated. On the other hand, the online travel companies do not want to pay tax on the lower net rate, on the entire amount that a traveler pays. They argue that under the language of the law, the statutes do not apply to the way they conduct business. What's the answer? Well, that's what we're all here to find out. The answer depends on how the Montana State Supreme Court interprets the laws of our state. This case involves both hotel rooms and rental cars, but I'm just using the hotel rooms as an example. However, the same principles apply to rental car charges. Now I'm going to try to explain the law. Our tax laws are very specific statutes. There are two taxing statutes at issue in this case. Both impose a tax on people who stay in hotels or rent cars. Both statutes use terms that are defined for purposes of the statute. Listen carefully. These are the two statutes you will likely hear attorneys refer to in their argument, and most likely the justices will ask specific questions about the statutes. First, there's a lodging use tax in Montana. It imposes a tax on the user of a facility based on the rate of accommodation charge. The lodging use tax is collected by the owner or operator of a facility. Accommodation charge is defined as the fee by the owner or operator received for the facility for lodging. Facility is defined as a hotel, motel, campground, resort, etc. The second tax statute is a sales tax. The sales tax imposes a sales tax on the purchaser of services. The tax is collected by the seller or person who makes the sale, lease, or rental of property or services. The services that are subject to tax are services for accommodations and rental charges for rental vehicles. The sales tax rate is applied to the sales price or total amount of consideration paid for the lease or rent of personal property or services. Both taxes are collected from the traveler and then paid to the state. And both taxes are based on a percentage of the cost of the room. The law could be that there's just a flat $5 or $10 tax on every hotel room. But instead, our legislature has imposed a percentage of tax, which means that the more a room costs, the greater the tax that is due. Under the statutes, there's a 4% imposed under the lodging use tax and another 3% sales tax imposed on accommodations. The statutes are imposed together, which means that there's a total of 7% tax on hotel rooms. For motor vehicles, it's a 4% tax multiplied by the base rate of the rental vehicle charge. The district court never held a trial in this case, not like the law and order type of trial you might be imagining. In this case, there was no jury. A judge decided the issues as a matter of law. Like many tax cases, this case does not depend on witnesses who might contradict each other. In fact, the parties, by and large, do not disagree about what happened. They disagree about the nature of the online travel companies' businesses and services. For the online travel companies to be liable for tax, they have to fit within the definitions of the taxing statutes. To make that determination, the district court reviewed contracts and agreements between the online travel companies and the hotels and rental car companies it works with in Montana. The district court followed principles of statutory construction in making its decision. Those principles are that courts are to read the statute and give plain meaning to the statute. If the statute is ambiguous, the courts will look at the intent of the legislature or the policy or purpose of the statute. The district court determined that the online travel companies are not liable for the tax based on the district court's interpretation of the taxing statutes. Essentially, the district court decided that online travel companies are neither operators or owners of facilities nor sellers of accommodations, and therefore the taxing statutes do not apply to their activities. Instead, the district court said that online travel companies are more like travel agents. The district court characterized the online travel companies' business activities as providing arrangements and reservations for customers. And based on that characterization, the statutory language does not apply to the fees that the online travel companies charge on the markup. Furthermore, the district court found that there was no legislative intent to tax services like those of a travel agent. When the State Department of Revenue lost at the trial court level, they decided to appeal the decision to the Montana Supreme Court. I don't know exactly what the parties will argue today, but you may hear the Department of Revenue, or the Department of Revenue likely will argue that the online travel companies' activities and the nature of the services provided by the online travel companies make them liable for the tax. You may hear the Department of Revenue talk about construing the statute more broadly. The Department of Revenue wants the court to interpret the statute in a broader interpretation. They may argue about the purpose of the law and the intent of the legislature at taxing the entire amount a traveler pays for a room. On the other hand, the online travel companies will likely argue their activities and the nature of their businesses do not fit within the activities or definitions provided in the taxing statutes. The online travel companies will likely argue for a strict or literal interpretation of the statute. They will argue that the statute must be construed narrowly, asking the court to pay close attention to the literal words of the statute and whether the online travel companies' practices fit within the statute. Today, you'll hear argument from both parties. The State Department of Revenue will present their case first and will set forth the reasons why the district court's order and judgment should be reversed. The online travel companies will then respond to the arguments of the state. And then the travel companies will have an opportunity to rebut the arguments made by, then the state will have an opportunity to rebut the arguments made by the online travel companies. Recall that the justices and their law clerks have already read the briefs of the parties. The purpose of oral argument is for the court to ask questions of the lawyers of the parties. The justices will likely interrupt the attorneys with questions. It's an opportunity for the attorneys to have a conversation with the court. The justices are concerned not just with the outcome in this particular case, but also how the outcome in this case may affect future disputes and future transactions. The justices may ask hypothetical questions. The justices will not indicate today which party prevails. After the argument, the justices will adjourn and meet in conference to discuss the case, and one justice will be assigned to draft the opinion. The justices will circulate the draft decision to the other members of the court who may suggest changes. The final opinion in a few months' time will be filed by the Montana Supreme Court, with the clerk of the court, and it will be printed as an official set of court decisions in the Montana reports. Those of you in the audience who are high school students, Some of you will decide to become lawyers. Of those of you who become lawyers, a few will become judges. Perhaps there are some of you in this room who will sit on the Montana Supreme Court in the next generation, hearing cases like this. Before I conclude, I invite you to think about the significance of this case in the broader context. How do our laws change and evolve with changing times? When the legislature enacted the lodging taxes at issue in this case, it was before the widespread use of the internet. Certainly, the legislators were not thinking about booking hotels through online travel companies. I want to impress on you that what you're about to watch is a very big deal. You're witnessing one of the branches of our government, the judiciary, serve our state. And it is with excitement that I welcome you to listen carefully and learn as we hear the State of Montana Department of Revenue versus Priceline.com. Thank you.
Seated.
Sorry.
Good morning. This is the time set for oral argument in cause number 140260, Department of Revenue versus Priceline, Inc. Before we start, I'd like to take the opportunity to introduce the members of the Montana Supreme Court. On the far left, my left, your right, is Justice Jim Rice, then Justice Jim Shea, Justice Lori McKinnon. On the far end is Justice Pat Cotter, Justice Beth Baker, Justice Mike Wheat, and I'm Chief Justice Mike McGrath. We're very pleased that you're all here today. We promise we'll keep the attorneys on time. Counsel ready to proceed? Mr. Krongeier.
All right. May it please the Court, again, my name is John Krongeier, and with me is Kristen Baytall and David Paoli of the Paoli-Kutzman firm, as well as Teresa Whitney on behalf of the Department of Revenue. I'd like to start off by asking all of you to think about a hotel. Just visualize in your mind perhaps a hotel you know or like, or maybe the DoubleTree where a lot of us stayed last night, I know. And right next to that image of a hotel, I would like you to think about a hotel guest. What you're envisioning is the choice that states face and governments face when they decide to tax in this realm of accommodations. And Montana has made its choice. It made it in 1987, and it made the same choice again in 2003. It decided not to tax hotels. It could have done so. It could have easily passed a property tax or an excise tax on the privilege of doing business as a hotel. Some states have laws such as those. Montana does not. Montana's law is on the hotel guest or the user or purchaser of the right to stay. And that fundamental difference, which we'll get to, drives many of the decisions around the country and respectfully, properly considered, should drive the result in this case. Because, again, the hotel guest is the taxpayer. That who question of who is the taxpayer is fundamental. And the second crucial question is, what is the tax basis? What does the taxpayer need to pay? And the law provides the answer very directly. The taxpayer needs to pay the total consideration, referred to in the sales tax as the sales price, gross receipts in the former law, but broad language. total consideration paid by the guest, who again is the taxpayer. And so when you consider these two facets, the who and the what, Montana's law comes into clear focus that these are not taxes on the physical building, a hotel, and they are not taxes on the physical handing out of keys. These are taxes on the fiscal aspects of these transactions as seen from the eyes of the guest, who is the taxpayer. And that's the first fundamental pillar of this case, is that there's this financial focus that you see again and again in these statutes, as opposed to a physical focus that you see in other statutes.
Mr. Krongard,
Yes.
your opening remarks lead to my initial question about this case. In the briefs, you fault the district court for mixing and matching the provisions of the two chapters, Chapter 65, the sales tax, or the accommodations tax, and Chapter 68, the sales tax. Yet, in the briefing and in the department's rules, the department itself seems to conflate the two, despite marked differences in the plain language of the statutes. Is it conceivable that the court could uphold the application of one tax and not the other?
It is conceivable that that could occur, but given what the question already presumes is that there was an intent by the legislature to deal with the same subject matter in peri materia, to deal with the same subject matter. And this court's longstanding case law says that when a court is construing two different statutes dealing with the same subject matter, it should try, if at all possible, to arrive at a reasonable construction that gives meaning and full effect to both. And I would add to that, as this court knows, the longstanding case law is that a statute passed later in time dealing with subject matter controls over one passed earlier, and a statute that deals with a subject in more specificity, in greater detail, controls over one who is more general. So I think all the parties recognize there is different language used in the different statutes.
I guess the question there in
Sure.
council is do the two taxes, in a word, sink or swim together with regard to this issue? It seems like after the legislature enacted those two taxes, it was the actions of the department, both by regulation in terms of binding them together and in their enforcement, have bound them together into one rule. And I'm wondering whether then they both would be interpreted the same way with regard to the issue.
We think they should be interpreted the same way, but I think, as your question points out, starting in 03, we have two sets of laws to go on with new combined rules, and the new law passed deals in the sales language, sales price, seller engaged in business type language, and the new rules, as you'll notice, have been steadily progressed in that direction as well over the years. In fact, so much so that the new rules applying to both laws deal with seller and sales. So I think they should they should swim together, but the later, more specific law needs to be guiding. And as this court has pointed out, the latter law is paramount to the former, citing the Montana Association case from 2008. And so now, if despite trying to harmonize the full panoply of both of these laws, using every tool available and considering reasonableness, the court were absolutely unable to reconcile them, then at that point, that would mean that the 2003 law and the earlier law could be construed differently. But at all costs, they ought to be try to be construed the same way. And again, the recency and specificity of the later law controls under the binding authority of the state. I started off by mentioning the pillars of these transactions. The first one is that they have a financial focus. The second pillar is something we all expect in laws in general, and it's built into this law, in both of these laws, which is equality. Taxpayers in this state expect to be treated the same way when they're engaging in similar transactions. And as the introduction to this case points out, from the traveler's standpoint, they're being charged $100 no matter how they get the room. There are these rate parity agreements where in the marketplace, essentially these rooms have to be priced the same way. So from the traveler's perspective, they're paying the same amount, they're paying the same sales price, they're paying the same gross receipts under the old law. They should be taxed the same way. And that equality provision is the second pillar. The third pillar of this case is transparency. I mean, this goes back to our nation's founding, which is nobody likes taxes. We all understand that. Businesses don't like them, individuals don't like them. But when there's going to be a tax, and Montana has chosen to have this tax, taxpayers are entitled to know what they're paying in taxes. It makes common sense, but it also comports with your law, with Montana law. 1568 says that the taxes shall be separately stated for all sales. It's just black letter, clear law. And that, by the way, has been on the books as well in the rules, which since 2003, the combined rules say that the separate statement of tax must occur even under the old law. And that provision has been violated in every single transaction engaged in by the OTCs. I think more than 1 million transactions now. 1 million travelers who've come to this state, or 1 million bookings, and who have not gotten the transparency that the law requires. And I mentioned the separate statement that is found in the 03 rules, but it goes all the way back to 1987.
Counsel,
yes.
if I could interrupt you for a minute.
Sure.
Do you recognize a distinction, and I'm looking to outside authority as well, between an emphasis on the transaction, which is apparently the argument you're making, versus a facility? And do the 3 statutes that we're looking at, can you discuss whether it's a transactional focus or a facility focus, and where in the statute we should look for that answer?
Sure. I think that the first place that we should look to is where I started. Who is the taxpayer in these cases? Who is the tax imposed on? Because again, if Montana chose to tax the facility, strictly the building, as the other side is suggesting in their briefing, again, there would be no need to tax the user. You could tax the facility directly and make them the taxpayer whose the tax is imposed upon. But this structure, if you look at the language very clearly, it uses imposed language for the user. And later when it talks about the seller and the responsibilities of the seller, it says they're subject to the tax. That's a very clear delineation. What it means is they both have responsibilities under the law, but the user has the ultimate responsibility to pay the tax, and that's why the entire perspective of what the tax basis is seen through their eyes, through their lens. Now, the sellers are subject to the tax in the sense of tax collectors. They have an obligation to properly and fully collect what the user owes and hold it in trust, because the money belongs to the state and to the Department of Revenue from the moment it leaves the credit card account of that user, all the way until it makes it to the state of Montana.
Counsel, what significance should we attach to the fact that the Department attempted to incorporate into these tax statutes in 2007 the companies essentially that are at issue here, and tried to incorporate intermediaries into those statutes, and the legislature decided against that? Isn't the decision on tax policy the responsibility of the legislature rather than this court?
The legislature certainly has the responsibility to create laws. I guess what we're saying in this case is the legislature did that in 87 and 03 in these laws, and I will address the 07 in a moment, but in these laws, properly construed, strictly construed, right down to the deductions in the exemption section under the Bates and Westmoreland cases, requires a tax on the user for the full sales price. So in other words, there didn't need to be a new law. The law on the books is what needs to be construed. Now, their argument, I guess, it wasn't relied on by the district court, but their argument has been somehow that this is an admission of fact that should control this case, that there was some loose comments made in the 2007 timeframe by one employee somewhere in that process that suggested the existing laws didn't cut it. There's 2 problems with that. The first one is legal. As this court knows, the only time we get to legislative history is if the plain and ordinary meaning of the statute isn't clear. And these statutes say sales price over and over again, and full consideration, and services included, and no deductions. The language is clear. We don't even get to legislative history. But the second point is, even if you were going to get to legislative history, I'm not aware of any case that says the legislative history of a different law that didn't pass is to be used to interpret the laws that did. I mean, the two laws in question are the 87 and the 03 law, and what was the intent and the legislative history of those acts, which is very supportive of our case, should the court need to look at those. Because again, it makes clear what the user focus was. In fact, the hotels of this state were very clear in making sure that they were not the focus of the tax, that it wasn't a facility tax. That's why the Montana Innkeepers Association supported these laws. They wanted to see capital gains tax go down, and to horse trade in that proposition as part of the passage of these bills, they allowed or were supportive of a tax on their users that came to their facilities, but they didn't want to be directly taxed. And that was, again, the choice made. So I think legally it can't control these other laws, but I think also I would point out that if that were somehow material to this court's inquiry, at best it would be a dispute of fact about what the department was saying at that point in time. Because the very next day, after the House bill comments that they have cited very heavily came out, there was an official memorandum, and I have it with me on the podium. There was an official memorandum that went out by the Department of Revenue, and we've cited it in our brief. And it's got the official seal of the state, the governor, the Department of Revenue, and it's not by an employee, it's by the director of the department. And it said very clearly in writing that this bill, the House Bill 147, was not a new tax. The existing tax already covered the online travel company services. And then it goes to the point I made earlier, the Bates-Westmoreland type point, by saying nowhere is a deduction found in the law for those services. The only thing it deducted are meals, transportation, and entertainment. So at best, there would be mixing and matching testimony that they think supports them, as opposed to an official memorandum from the director that at least cuts the other way. So, and I think if we, at some point, there has to be, if there is that kind of issue, it's going to be decided, we have to look at the full evidence. The testimony in this case from all the department witnesses was that the law covered them, and there's no exception for services. The memo says that, the legal complaint says that. But again, legally it's a different act. It didn't even pass. It doesn't control. And if it did, it would be disputed evidence. So, thank you, Your Honor. Briefly going back to a couple of the points I wanted to make. I've covered the three pillars of this case, and I mentioned the tax transparency point. I want to get to hopefully one thing that narrows the focus of this court's inquiry. This is a little different than some tax disputes in which there is a taxability issue. And courts have to wrestle with whether taxation was even triggered in the first place. Perhaps whether a statute is ambiguous and ought to be construed in favor of the taxpayer. That's the body of law that the other side cites. But we're past that in this case. Everybody agrees that when a customer goes to Hotels.com's website, puts their credit card down, clicks accept or confirm, and pays for a room and then goes and stays in the hotel, everybody agrees a taxable event has occurred. And why is that important? Because when we're past taxability, we then arrive at what this case is really about, is what the tax basis is. And that leads us to where the body of case law that decides this case is, deduction or exemption case. That's what this is really about. And that's what the Wyoming Supreme Court found in its 5-0 decision against these companies on a very similar sales tax case. As I said, when you boil it down, this case really is that the OTCs argue in effect that the putative facilitation or service fee is an exception from the sales tax. That's their argument, and they're entitled to make that argument. The problem with the argument is we have to go to the law. And the 1565 law lays out the exceptions or deductions very clearly. They're limited. Meals, transportation, or entertainment. They just don't qualify. The newer combined set of laws passed in 03, the sales tax, mentions similar services under the Latin principle of a justum generis. Telephone, Wi-Fi, laundry, personal laundry. What do all these services have in common? They are optional services. The customer does not need to use them to use the room. They can use the room without ever incurring any of those costs. They're non-integral charges. And those are really the two requirements when you look at the code carefully. The 68 sales tax code says there are basically two things you need to do to have an exception. One is you need to be on the short list. They're not. But two, even if you were, even if they provided entertainment or telephone charges, they'd still have one other procedural hurdle they'd have to do to get an exception, which is they'd have to separately state what those charges are. It goes back to the transparency principle. The law is very clear, and the rules go along with the law, that when companies combine charges together, even if the whole thing wouldn't have been taxable in the first instance, it becomes taxable. The legislature built policy, smart policy, into the law. Why is that? Because if everything's bundled together, the Department of Revenue is at a distinct disadvantage to really sort out how the charges were allocated and if it was done correctly. The taxpayer, the user of the room, is at a distinct disadvantage of even knowing what they're paying taxes on. Doesn't comport with our democratic system, an entitlement to know, at least if you're going to pay the tax. So they fail on both counts. Substantively, they're not entitled to a deduction or exemption. And procedurally, even if they were, they didn't take the steps to comply. Bates and Westmoreland cases dictate the result in this case. And the way the Wyoming Supreme Court put it was very appropriate. The Wyoming Supreme Court had the almost identical definition of sales price. I mean, to the point where I don't know if a comma or a word is different in their definition of sales price. And one of the things that makes clear in the definition of sale price is there's no deduction for services necessary to complete the sale. And that's really what we're talking about. Because if you go to the Hotels.com's website, you do not have the choice to say, I just want the room. I'm not going to surf your website. I don't want to comparison shop. I understand you might offer some interesting maps or ratings. I'm not going to read any of those. I don't want your services. I just want the room. You can't do that. It's an all or none proposition. You either pay the full price, the full sales price, and you get the bundle of rights, everything that goes with it. You get to go stay in the room, or you don't. And so that qualifies clearly as a service necessary to complete the sale. And it's no different than a hotel booking. We all know what happens with a hotel. You don't, when you pay the DoubleTree $100, the DoubleTree's not allowed to say, well, $80 was for the room, but we spent a lot of money. We have a website, Hilton.com or DoubleTree.com. That costs us money. We had to process your credit card. That costs us money. We want to deduct all those services. We have customer service representatives. They can't deduct any of those things. And this gets us to the important principle of your law. In Montana, the state law is clear. A person cannot do indirectly what is prohibited from being done directly. And that goes back to the Bottomley v. Ford case, the Evans versus Helena case, 1921. It's a long-standing doctrine. And that's really what we're talking about. As the introduction to this case points out, a traveler can't go to the hotel and then deduct from the tax basis advertising and marketing costs. Why can they do it when the online travel companies are involved? The law of Montana does not change when a person uses a direct booking, an indirect booking, the number of people in the stream of commerce. The order the money flows doesn't matter. Really, that's what their argument amounts to, carefully considered. What they're saying is it's undisputed that travel agent transactions are fully taxed. Brick and mortar travel agent transactions. Really think about that. Travel agents, despite the fact that they provide services, the hotel, if they take in $100, they don't get to deduct what they pay to the travel agent. There's no deduction for it. So why all of a sudden does it matter if the online travel company or an online travel agency takes the money in first and divides $80 after the fact to the hotel? The
Counsel,
yes, sir.
Go ahead, no go.
When you talk about sales price, though, the department itself has determined that to be synonymous with the accommodation charge, which specifically references that the accommodation charge is by an owner or operator, which I understand is not defined, but just in terms of the common definition of what would constitute an owner or operator, how does, if they're synonymous, as the department itself says, then how does an OTC fall under the definition of, I guess, just the common definition of owner-operator of a facility?
Sure. I think there's 2 points to be made there. The synonymous rule, I believe, went through in 2010, for starters. So we have 03, 04, all the way up to 2010, where that provision's not even in effect. So to the extent somehow that's controlling, it can't control for the years leading up to it, which are, there's 7+ years there. The second point is we have to remember that the statute obviously controls, and we can't use that phrase of a rule that the two are synonymous to somehow nullify everything that happened in '03.
But if the department is a litigant here, and if, as you pointed out, there was a letter by the administrator of the department, which we're supposed to take to the extent that it informs our decision
Sure.
in any fashion, then isn't a rule promulgated by the department to carry even more weight in terms of an admission by the department?
Sure, but
irrespective of the time when that rule was promulgated.
Yes, Your Honor, I think that's correct. I think it's more what does the rule mean, I think, where the point of distinction is. The department wasn't intending or meaning, and certainly didn't say that it was trying to wipe out sales price and seller. In fact, again, if you look at the evolution of the rules over time, they've moved away from any owner-operator language and towards sell and sale. What they were saying was they were trying to say that when you look at the old gross receipts and accommodation charge language, don't look at that in a limited way. Look at it in our more modern way of phrasing this. It equals, synonymous means equals. It goes in both directions. They're saying look at it in the way sales tax is defined. Look at it that way. And I think if, again, they didn't say, what they didn't say is sales price is defined as the legacy language. They said the two are synonymous, which again gives me back to that language I quoted about the Montana Sporting Association case. You have two laws. You're supposed to give effect to all of it. So how do you come up with a definition that does justice and affects sales price and one that affects gross receipts? There's one reasonable construction that accomplishes that, and that's the one provided by the DOR. We cannot use the former law to refute or to nullify the later one. I'd put it this way. If the legislature of the state and the Department of Revenue wanted to just raise the tax rate but keep all the old language, they could have done that. We wouldn't need a sales tax. All they could have done is change the tax rate from 3 or 4% up to 7% and left all the old owner-operator language. But the legislature didn't do that. They came in and they put forth a whole body of legal provisions, the presumption of taxability that I really haven't gotten to, but a powerful provision to assist courts in interpreting this, saying you're to presume that these transactions are taxable and presume that the tax amount is on the full retail price. And anyone who comes to try to argue otherwise, it is their burden. They have the burden of persuasion. So I think taken in its entirety, that clause can't be used to defeat the law. It actually assists the interpretation of the former law.
But
and that
Mr.
was the intent of the
that
department.
gets back to my first question, which is the legislature didn't just add these provisions on top of or replace any of the accommodations taxes. The legislature created an entirely separate chapter, and most of the language that you've been talking about in terms of the total consideration paid and the presumption of taxability is only in the sales tax statute. So I'm having trouble with your argument that the two have to be construed in pari materia because of that's a tool of statutory construction when the plain language seems so different.
Sure. I think the point is that the language is different, but properly construed, they end up coming out the same way. I'm not suggesting that the language of either is disregarded. That's improper statutory construction. But if you consider the Department of Revenue's position in this case, from '03 on, the 68 law is very clear, and it ought to be just like Wyoming. With respect to the old law, I admit that there is less law to go by and less rules to go by in different language. So let me say a couple of things directly on the old law. The law is not just based on dictionary definitions, and I think recently the court, and it might have been Justice Rice writing the decision, I think in the MCI case, said when we have dictionary definitions should not be used when we have statutory ones. And that's true here. So we're not stuck with saying that owner-operator facility means whatever that means to the common person as they define it. We had definitions, and so we have to construct the old statute. And there's really only 2 or 3 pieces you need to do that. First, you need to look at the pieces before you put them together. The first one is, what's the definition of a person? And the definition of a person includes not just a single individual or a single company, a hotelier, they could have written that. It says it includes any individual, corporation, joint venture, group, unincorporated group. And what is the legislature, or excuse me, the rules were saying that we understand that hotel rooms may be sold by more than one person acting together. Maybe it'll be a hotel and a travel agent. That's why travel agents have been taxed under the old law. And that's the real distinction. The custom and practice of the Department of Revenue has always been to tax the full value when travel agents are involved. And so we have this broad definition of person that includes multiple companies working together. The second piece of the puzzle that you need is, what is a facility? What is a lodging facility? And a lodging facility is defined as an individual room within the larger facility or building. So you got to, when we put the definitions of owner and operator together, the definition means any person, keep in mind now that can mean more than one company acting together, or organization who rents a lodging facility, meaning an individual room. And let me just stop there. Does Hotels.com rent an individual room? Of course they do. That's the plain meaning. Now, the last clause, and it says to the public, and that's what they do. These are retail transactions. And the last part says, and is ultimately responsible for the financial affairs of the facility. And the other side says that doesn't apply to them. But again, we have the focus of this on the financial. And let me quote the Supreme Court of Wyoming, which said, the OTCs, not the hotels, thus control the financial aspects of this transaction completely. They take over. They're the merchant of record. They handle all the money. They're the ones selling those individual rooms on those nights, or at a minimum, they're joint venturers or unincorporated groups acting with the hotels to sell the rooms together. It doesn't matter. The law isn't defeated by a company such as a hotel outsourcing services. The result needs to be the same. Goes back to you can't accomplish indirectly what is prohibited directly. Let me just wrap up with a few remarks so that I save some time, if I may. I understand, well, let me say one thing on the rental cars. The rental car is found under the sales tax. There's no old law to reconcile with it. There's one law, and it's found under the sales tax. It is on the base rental charge for use of the vehicle. And again, the tax is on the user. So it's seen through their eyes. When a customer goes on to Orbitz' website and rents a car, and they pay, they're quoted a daily amount, what are they paying to use the vehicle for that day? It's the retail price that's shown. That's the base rental charge they're paying. Now, they're not paying for fuel charges and other things, but they're paying the base rental charge. It's very common sense, plain, ordinary meaning. And the contracts make it very clear there's 2 provisions that are relevant. The rental car contracts establish that they have discretion. They set the price. They handle the consumer transaction. They're the ones you go to for a refund, just like with hotels. And they take on, in many of their contracts, to show how ingrained they are in Montana's tax system, they take on responsibility for the taxes. Contractually, they agree in many of the contracts to defend, indemnify, and hold harmless the rental car company. They're saying if there's a tax issue on this markup, we've got it. It's not your problem. We're responsible for all taxes because they're their customer. It makes sense. It goes back to the fundamental principle of contracts come with rights and responsibilities. They can't just get all the benefits of being able to trade in these transactions and charge and collect the tax dollars and have no responsibility. And so on the old law, I would just leave it with this last point is they haven't adequately explained why it is that travel agents' transactions have been taxed all along under the old law and the new. There's no credible explanation for that. The Hawaii Supreme Court understood that they were at a minimum travel agents. I think they do much more than standard travel agents do, which makes them even more liable, but they're at a minimum that. The Supreme Court of South Carolina and the Supreme Court of Wyoming. You have 3 state Supreme Courts on 3 state-level taxes like this one, especially Wyoming, which is on all fours. it requires liability in this case. So let me just conclude by saying this. I know that they're going to make counterpoints, but as they're making their presentation, I'd ask you to ask yourselves, are they respecting that pillar I started with? Are they treating this more like a facility or a hotel tax, or are they respecting the fact that these are user taxes, sales taxes? Are they explaining really how a tax that has the word retail in it, the 68 tax, are they explaining how somehow a retail tax scheme based on charges to the public becomes a tax on undisclosed wholesale prices for which none of us can obtain a room? Are they adequately using the later law that is more specific and there's more to it to, at a minimum, try to guide the interpretation of the earlier law, or do they have that process backwards? And are they trying to hamstring the later law based on the former? Are they respecting Bates and Westmoreland that deductions are construed narrowly? Are they applying to any extent the presumption of taxability that was not used at all by the district court and that they say shouldn't apply? They want you to nullify or disregard that. When you boil it all down, their argument amounts to this proposition. They are arguing that Hotels.com is not engaged in the business of selling or renting hotel rooms. And I'd ask you to really think about that. Thank you.
Counsel, real quick before you sit down, what are the tax years at issue in this case? I couldn't discern that from the briefing.
Yes, Your Honor. The tax schemes run from 87 all the way to present. I should point out some perspective on these new and old laws. 97% of the money at issue, 100% of the rental car transactions at issue begin in 03. Because the OTCs were not doing very much business until the very late 90s or the early 2000s. So by the numbers, in terms of number of transactions, amount of money, years in operation, most of this case, I mean, so we don't get the tail wagging the dog, most of this case is on the new combined set of laws that go into effect in the 2003 timeframe. But the practices continue to this day. A part of the relief being sought was injunctive and declaratory relief, and to this day, the companies continue to collect on what we say are higher retail rates. They apply Montana's tax rate to the retail price, but only remit on lesser amounts or no amounts at all in what you've seen in the briefing called breakage transactions. So that's an issue of fact, that was a dispute of fact that the district court didn't acknowledge that should have been fatal to their summary judgment motion.
Do I understand you're claiming taxes then back to 2003? Is that what you're saying?
No, I think the very first transactions, Your Honor, go back to about 99. But what I'm saying is that by the numbers, there's very minimal transactions from 99 to 2003. So there are a few in that 99 to 03 window.
Thank you.
Sure. Thank you.
Good morning, Mr. Chief Justice, Justices. I'm Mike Green from the Crowley Feck Law Firm in Helena. I'm here today representing all of the online travel companies which were sued in district court in Lewis and Clark County by the Montana Department of Revenue. With me today is Elizabeth Harrington, one of my co-counsel from McDermott, Will & Emery in Chicago. Your Honors, as a tax litigator, I'm really appreciate the opportunity to appear before you at my alma mater and argue this case. As Justice Cotter seemed to boil down, in this case, the department is really trying to do through litigation what it could not do through legislation. It's attempting to expand Montana's lodging and rental car taxes beyond the plain meaning of the statutes. And it's attempting to do so and convince this court to head in a policy direction that the Montana legislature expressly rejected in 2007 when the department presented House Bill 147 and asked to have changes made to make these companies expressly subject to Montana law. As you've noted in some of your questions, there's simply no way to reconcile the department's position in this litigation with the position that Mr. Walborn, who is a high-level administrator and currently the deputy director of the Department of Revenue, not just some random employee, stood up in front of the Montana legislature, the House Tax Committee, and said, if we sue these companies, we are going to lose on this language because they are not owners or operators of hotels. This is not some random employee. This is a policy-making employee of the Department of Revenue.
Mr. Green, do you have authority for how this court is to consider, in construing a statute, legislation that didn't pass?
Your Honor, I think that the court is free to consider, in the case of an ambiguity, any legislative history that it wants. I submit Mr. Walborn's testimony in this case for the purpose, and House Bill 147 for that matter, because it was the department's position of what needs to be omitted from the statute in order to tax these companies and what needs to be inserted into the statute to tax those companies. So House Bill 147 is the department's own language about what changes it would have needed to make to Montana law at the time in order to extend this tax to online travel companies.
So we would only examine that if we concluded that the plain language didn't resolve the construction issue?
I think that's correct, Your Honor. Other than I think Mr. Walborn's testimony in that case and other pre-litigation statements of the department should call into question their positions in this civil litigation, because they have a long-standing practice of incorporating of administering the two Chapter 65 and Chapter 68 as a single bed tax.
And do you agree with Mr. Krongeier that the statutes sink or swim together?
I absolutely do, Your Honor, and I think that's borne out by the legislative history. The Montana Chamber and the Montana Taxpayers Association submitted an amicus brief in this case, and with that was an appendix. And it has the two versions of the original sales tax bills in there. And you'll recall in 2003, the Montana legislature undertook an income tax reform effort at the urging of the Martz administration. And part of that was kind of a relatively broad tourist-type sales tax. And there were 12 or 15 separate items that were going to be taxable under that statute. So, Justice Baker, to your question about why didn't they just amend the original statutes, the answer is because they were anticipating on introduction a much broader sales tax than we ended up having at the end of the session. And so, but if you look at the language, and I've put in front of you the definitions that came out of, in a handout, that came out of that legislation. If you look at title, at 101, which is tab 6, you can see that in adopting that sales tax, they adopted a definition of accommodations, which is virtually identical to the definition of facilities, which is under the bed tax, the 1987 bed tax in Chapter 65. Under tab 5 is really the imposition statute, and this is the statute which I think says on its face that these statutes are tied together, and that is the new tax, which is a general fund source now, is a 3% tax on accommodations and campgrounds. Now, the department has reinforced the co-administration of those taxes, if you will, in the rules that it got around to finally adopting in 2010. I will note, Your Honors, the department did not adopt new rules interpreting the 2003 Act until after it had hired outside counsel in this case in late 2010. But they did, right after the legislature left town in 2003, issue the guidance which we provided to you as Appendix A in the appendix that we provided. And the department clearly set out in the months after the legislature left in 2003 that Montana now has a 7% sales tax on lodging. It's a combined tax. And it says those who provide lodging must collect the tax. It then goes on to say, under the definition of owner and operator, which we seem to have some confusion about between our side and the department, this is on page 2 of their document on Appendix A, the last sentence of the owner and operator statute says, the owner and operator has the final say in the business and is liable for collecting and remitting the lodging facility use tax to the department. That adds on to the language which the department then had incorporated into its rules about the owner or operator of the facility being the entity that is ultimately responsible for the financial affairs of the facility.
Counsel, can I interrupt you? I mean, let's get away from what the department was talking about in its rules, and let's look at the statute for a second, okay?
Absolutely.
And I'm talking about 1568. In 1568-102, subpart 2, 102 talks about the imposition of the tax, and in subpart 2 it says, excuse me, the sales tax is imposed on the purchaser. And then farther down in subpart 4, it says the value of property must be determined as of the time of conversion to use. A couple of questions here. The first one is, who's the purchaser and who's the seller here? That's the first question. The second one is, what's your interpretation of the time of conversion to use?
Your Honor, if I can very quickly take them in reverse, because subsection 4 is actually part of the use tax, which we really don't have in Montana. Use tax is the tax that applies if you purchase property outside of Montana and bring it back to Montana and you've not paid sales tax in that state. It is borne by the user, it's paid by the user, it's a separate tax. You can't really pick up accommodations and haul those into Montana. So subsection 4.
So it doesn't apply here to somebody who rents a hotel room and pays the full wholesale price, but they buy it through Priceline or whoever, and they pay they pay the full price there, but Priceline is paid less.
Well, Your Honor.
So the use is not when they go and check into the room.
Well, the use of the hotel room is certainly when they go to check in the room, and that's the taxable transaction. Use for purposes of the sales and use tax is not an issue in Montana. And I suspect even the department would agree with me that we're not going to try to collect directly from users an additional tax.
All right, I'll accept that from you. But if it is at the point in time when the person who checks into the room is when they're going to use that room, if they buy the room themselves and they buy it for $100, like counsel earlier said, they pay tax on that $100, correct?
That's correct, Your Honor.
But if they get it through Priceline or one of these other OTCs, they pay the tax on the amount that the OTC is paid for the room. Is that correct? If it's $80, then they pay the tax on $80?
That's correct, Your Honor. They pay the amount that is collected by the owner or operator of the hotel. So in the terms of the statute, it doesn't matter what the OTC pays. The terms of the statutes are very clear. It's the amount collected by the hotel. That's the measure of accommodations charge, which the legislature in 1987 enacted.
Okay, let me go a step further here. It defines seller in subpart 16 of 68-101 as a person that makes sales, leases or rentals of personal property or services. Does that definition apply to the OTCs?
The statutory definition of seller in Montana does not apply to the OTCs.
Why?
Because they're not transferring possession or control of a room.
But they are selling a service, which is part of the definition that he just read.
Your Honor, they are selling a service. They're selling a service that allows people to view and to book accommodations from their computer. It allows them to package travel. It allows them to review travel options. They are not selling lodging services. The lodging services are provided by the hotels when those users go to check in. And so,
Counsel, let me ask you, but I mean, here's just as a practical matter, I mean, when I book on Hotwire and do a blind booking, I have to put my credit card in before I even know what hotel I'm getting. So how is that sale not being done with Hotwire as opposed to I don't even know what the hotel is until they've already got my credit card number. And I've already agreed to the agreement, the privity is exclusively between me and Hotwire.
Your Honor, I would put it this way. If my brother comes to me and says, I will go book a room for you, and you give me $100 and I'm going to go get you a room, and my brother can go to the hotel and negotiate a deal to get the room for $85 and pocket the $15, I don't really care. I was willing to pay $100 for the room.
But you're putting the cart before the horse there, because like I said, when I check in, if I've booked a room with an OTC, when I check in, I've already paid for that room. The only thing they ask for a credit card from me for is for incidentals. The purchase has already been completed before I set foot on the property. So that's the difference there between you and your brother is your brother has your money, and he can do whatever he wants with it, and that'll be between you and your brother. But then he is then making the transaction with the hotel, and that's the distinction is if your brother has already made the purchase before he leaves the room, you give him the money and that hotel is booked, that's the analogous situation. I mean, at the time that the purchase is made, it's done at my computer.
Well, Your Honor, certainly the reservation is made. By the time that the OTC computer talks to the hotel computer and the hotel issues a reservation number for you as the user, that reservation is made. Your stay is not completed. The Montana has not owed any tax at that time. There has not been a taxable transaction in Montana. Until a Montana hotel books revenue because of a stay or under its no-show policy or however it is that it might recognize revenue under that transaction, the sale does not occur at the time of the booking. That is a reservation.
So when I do a blind booking with Hotwire and they say that there are no refunds, and if I find out that I've got the hotel that I wasn't expecting because I agreed that it's a hotel in downtown Missoula and it's rated 4 stars on Hotwire, and I find out that it's not the DoubleTree or something like that, Hotwire's not going to give me my money back, right?
Well, Your Honor, under the scenario you've just said, if you book under a no refund policy, they very well may not give you your money back. That's a very specific situation that certainly doesn't cover all situations. There are lots of opportunities for the OTCs to issue refunds if someone is unable to travel or unsatisfied with their experience.
So would you agree that in those situations where there is no refund, that is then the full purchase price is taxable?
I wouldn't agree with that because in that situation, in the situation you've described, I'm assuming you're not staying at the horrible hotel that you don't want to stay at. There is no taxable stay in Montana. So that is not a taxable transaction. Montana taxes the use of lodging accommodations. We don't tax the transaction.
So let me ask you a little different question using your example with your brother. So your brother agrees to book a room under your example for you. You give him $100. He books the room for $85, pockets the $15. So the $15 under that scenario would be income to your brother, would it not?
If you chose to report it, Your Honor, it certainly would be.
Well, I'm assuming
he's a little sketchy, so I don't know if he would.
No, I know your brother. I think he'd probably report it. So that leads to my next question. Do the OTCs pay corporate income tax on the profit they made? Or
Your
the
Honor,
income they make
Your Honor,
for doing business in Montana?
Your Honor, I honestly don't know the answer to that question. What I can tell you is if they are subject to Montana income tax, because that's Montana taxable income, I have no doubt that those companies would pay. But the taxability for a lodging accommodation, the Nexus standards, and I'm getting into this little tax policy wonky stuff, Your Honor, but the issues between income tax and who is subject to and required to pay an apportioned income tax is a much different issue than we have before.
I think there's something in the depositions that in terms of price line, they do not pay corporate income tax.
It certainly wouldn't surprise me if they didn't, Your Honor, because they don't have employees here, they don't have property here, and their sales are deemed to occur at the site of their server. So as a tax lawyer, that wouldn't surprise me that could be the case.
Counsel, what significance, if any, was there or attention spent on a contract between the online companies and the hotel? And should we be concerned about that?
Well, Your Honor, the contracts actually, if you're interested in reading the contracts, they set forth pretty clearly that the OTCs are really helping the hotels, under that scenario, market their rooms. But if you read through those contracts, they all say the hotels retain the right to set price, they retain the right to set the availability, and they retain the right to issue reservations. They are also universally responsible for remitting the taxes that they're required to collect and remit to the state. Now, after localities started suing the online travel companies to collect additional tax revenues on their service charges, some of the hotel chains asked for indemnification provisions. And those indemnification provisions in plain language say, hey, Priceline, if the state of Montana tells you you owe more tax, you can't come to us. You will indemnify us and hold us harmless from your tax liability. There is nothing in the contracts that would obligate any OTC to pay the taxes which are collected, reported, and remitted by the hotels in this case in Montana. So the contracts are very clear that we are a conduit. We provide an opportunity for hotels to broaden their exposure to a greater number of users, to allow us and my clients to package travel options and to give them additional options to shop for lodging in Montana that they might not otherwise have.
So is that the basis for the statement in your brief, which I wanted to ask, as a matter of fact, a hotel or rental company chooses whether to accept a customer's reservation request through an OTC depending on the company's current capacity, inventory or revenue management guidelines. So you're saying the hotel retains the ultimate authority to accept a reservation or not?
Absolutely, Your Honor. The hotel retains absolute authority as to whether or not a room is even listed on the site. They retain the absolute authority to issue a reservation as a part of the OTC transaction. And more troubling for some users, they ultimately retain the responsibility and the right to decide whether or not to allow the user to exercise that reservation and take the room. Those are all governed by the hotel's policies, and those are decisions made by the hotels. They set the price. They determine how many rooms they're going to make available. On any given time, they can take those rooms up and put those rooms up, take them down as they want. So that the availability and the amount, if you will, that they take advantage of the OTC services is entirely at the hotel's discretion. Just like it is for the user. Mr. Krongeier said you can't book a hotel room without without paying the OTC charge. Well, that simply isn't true. I suspect that most of us here who stayed at the DoubleTree last night had an administrative assistant or booked that transaction directly. Now, some of my co-counsel may have booked through our clients, but most of you knew where you were going to stay and booked that directly. This is the beauty of the Montana tax system and the original bed tax. In every lodging transaction, there is a hotel and there is a user. Now, there can be innumerable intermediaries between there. There might be a bridal party who books discounted rooms at a block. There could be an administrative assistant who's helping us out. There could be a traditional travel agent, and there could be my little brother, who are all in the middle of that. But in every transaction, there's a hotel and a user. And so the fact that we're taxing the user, the simplicity and efficiency of this statute is that in every transaction, we know there's going to be a hotel to which that user is going to have to show up and presents the opportunity to collect the tax that Montana is due.
Could you address Mr. Krongeier's comment that travel agents are taxed?
I can. Traditional travel agents, what's called the agency model, work on a commission basis, and so they're actually paid by the hotels. And so now there are travel agents, and it happens a lot for example, in the airline industry. I think it's the norm now, where the travel agent charges his or her own fee for the booking. You pay the airline a fee and pay on top of that the travel agent a fee, which looks very much like the OTC's merchant model for hotel transactions. But we call this commission model the agency model. Those commissions are not separately subject to tax, but the amount in that transaction, the amount that the hotel charges, is subject to tax. So again, the hotel has collected in that. So if we assume there's a $15 commission, the hotel will have still collected $100, and there will be tax owed on $100. But the hotel, the owner-operator of the facility, collected that charge and has that money and can report it and remit it to the state of Montana.
And so the only difference here is the OTCs, even though they may collect $100, the hotel is only collecting $80, and so that's where the tax gets paid. And that's what this case is all about, isn't it? Is that $20 between 80 and 100? And whether there's going to be a tax on that. With that in mind, would you please talk about 1568-103, which is the presumption of taxability?
I will, Your Honor. 1568-103 on its own says every sale and provision of service in Montana is subject to tax. I shouldn't have to tell you, Your Honors, that that isn't true. That statement cannot stand on its own. And in fact, in the last brief filed in this case, where the department responded to the amicus brief filed by the Montana Taxpayers Association and the Chamber of Commerce, they really acknowledged that that presumption has to be read in conjunction with the imposition statute. Now, what that statute, if you harmonize the statutes, if you harmonize 1568-102 with all of Chapter 65, with the presumption in 103, what that statute says is all accommodations in Montana are presumed to be taxable. And if you provide accommodations that fall within the definition of taxable accommodations, those are presumed to be taxable. That statute doesn't say helicopter tours, legal services, bus tours, ski packages. It doesn't say any of those other services that you can get in Montana and are freely provided are taxable. So when you apply the specific imposition statute, the department is really arguing somehow this general presumption can expand the plain meaning of the specific imposition statute. And that simply doesn't comport with the rules of statutory construction by which this court is bound, where the specific has to govern over the general and where the provisions must be read to the extent it's possible to harmonize.
Mr. Green, in the definition of service, getting back to the sales tax statutes itself, the definition of service is distinguished from the sale or lease of property. And the sales price includes all the total amount or consideration paid for the performance of the service. And so the presumption under 103 is that that service is taxable. And if the service is distinguished from the actual property, what does service mean in the sales tax statute?
Your Honor, again, this is, I think, an historical enigma, if you will, because of the history of the adoption of this statute. As I indicated, this is a uniform act that in 2003 the legislature tried to use. It's a uniform sales tax act. We didn't have a sales tax act, and so they went out and found a uniform act. So we have these provisions. But what's taxable in Montana are accommodations in campgrounds and rental cars.
But
we don't tax services.
Except you're saying we should ignore that language in the statute. Because when you say what's taxable is accommodations in campgrounds, that specifically says this imposed on the sale of the following property or services. And then it has 3% on accommodations, 4% on rental vehicles, and services is distinguished from the lease of that property. So are we to just omit language the legislature has inserted?
Your Honor, I don't think you have to omit services because it doesn't apply here. If you go back and look at the original enactment in 2003 of this act, there were a number of services that would have been taxable, recreation fees and those types of things. So the legislature maybe could have done a better job of cleaning up this language when it struck all of those additional provisions of the additional property and the additional services that were going to be provided. But that doesn't change the fact that the imposition language is still limited to the leasing of accommodations and the leasing of rental cars. So certainly Montana could tax services. The issue before you is whether the legislature has decided that we will tax services, and I think that under the plain language of these statutes when read in conjunction, the answer is no. We tax lodging. And the department, through its rules, I might add, the department can't disavow its rules. It's here as a civil litigant in front of you, but it's a state agency. And under this court's binding precedents, the Whitehall Wind case, agencies are bound by their own rules. So it can't come in here and argue now that you should step away or ignore those. You should ignore those rules. And under the department's own rules, sales price for purposes of the 3% sales tax on accommodations is the accommodations charge defined by Chapter 65, which is the amount collected by the owner or operator of the hotel for the use of lodging facilities.
Is this court bound by the department's rules in construing the language of the statute?
I don't think that the court would normally be bound by the department's rules, except that these rules have been in place for a fairly significant amount of time, and people have relied on those rules. It also comports with the department's guidance, and the department is a litigant in this case asking you to do something in violation of its rules. So I think that the court certainly should give credence to the department's rules. Moreover, in this case, the department's rules comport with the plain language of these statutes and with the legislative history. When you look through the legislative history and the language that the legislature used in 2003, it wasn't intending to expand the tax. This sales tax on hotels was not meant to be a standalone tax. It was just an additional tack on to a tax that we already had in place on an existing tax base. And it's been administered that way since the legislature left town. I think that it became effective in July of 2003, or June of 2003, for hotels and campgrounds. And so I think it would be inappropriate for the court to not pay heed, at least, to the department's rules. And they've provided guidance to the extent that there were any limited holes in the statutes that needed to be filled.
In that regard, counsel for the department say they're seeking taxes back through tax year 1999. Are we to apply just the regulations and statutes that were in effect for those individual years? Is that your understanding?
Your Honor, counsel for the department forgets that Montana has a 2-year statute of limitations in place when we don't have a specific statute. So neither Chapter 65 or 68 provide a statute of limitations in the case of a failure to file, which this undoubtedly is. The OTCs have not filed returns. Under this court's Caterpillar decision, the general 2-year statutory provisions apply. And so we think, at worst, the court would only be looking at liability back to late 2008. This case was filed in late November of 2010. So it's a much narrower period. But we don't think you really need to get to the rules, because the statutory language, when read in harmony, as we think it should be, is very clear that this is a limited tax. Your Honors, I did want to address one issue, and then I'll try to close. The department has mentioned several times, and Mr. Krongeier read to you from the owner-operator definition the term facility, and just inserted surreptitiously into that definition this concept that a facility is a room. A room is a lodging unit, and that's defined under the rules. A facility is a building, and it's commonly known as a hotel, a motel, a lodge. The definitions are clear. Rooms are subparts of a facility, and the suggestion somehow that this room notion is binding should be dismissed out of hand by the court. Your Honors, I really request that you, and I urge you, to reject the Department of Revenue's attempts to smear the OTC's business model. They've been successful. They provide a valuable service to travelers around the country and around the world, in fact. And the fact that their model may result in a slightly lower tax revenue on a particular transaction in Montana simply can't drive the tax policy that this legislature has already set. You also must reject the department's efforts to expand these simple and efficient and plain statutes beyond their broad meaning. Simply put, Your Honors, there is no interpretation of the plain language of these statutes which supports the department's position, and there are no facts in the record to support the arguments that they've made to you about the business model. As a result, we urge you to affirm the district court's well-reasoned decision that the plain language of these statutes does not reach the OTCs or their service charges. Your Honors, I thank you for your time. I'd also like to extend our appreciation to the law school for hosting the reception last night and to the university for hosting us today.
Thank you, Mr. Green. Mr. Smith, how long does Mr. Congeyer have? 6 minutes.
Okay. Thank you again.
Mr. Conger, would you, the very first thing you talk about here, would you respond to the statute of limitations issue?
I will, Your Honor, if I make sure I get the audio back here. Okay. Sorry about that. Yes, with regard to the statute of limitations, that's a misstatement of the law. The law is very clear. Chapter 65, the statute of limitations applies for auditing records and doing anything that follows that within 5 years after a return is made. And that's one of the issues in this case. The online travel companies have never filed, as taxpayers are registered, they have filed no returns. They have in other places, in selected places in the United States, when they've been forced to do so by the courts, but they haven't in Montana. And so the statute's never begun to run because they still to this day haven't done it. Chapter 68 has the same provision, 1568-520, within 5 years from the date that the return was filed. So there's symmetry. The other one, I don't know if I cited the statute section, but it's 1565-113.
So if the department can collect taxes back to 1999, are we to treat tax years differently depending on the enactment of particular statutes and regulations along the way since then?
I think so. I think so, Your Honor. I think the only perspective that's helpful in looking at these statutory schemes over time is just assisting with the context. But I think, obviously, the laws and the rules at a given time that are in place should be applied. I think the point of departure, though, is what the rules were at the time. Mr. Green just stated that a lodging facility doesn't mean a room, and you should reject that. But 1987, the term lodging facility means a unit or units within a facility. It's down to that room level I spoke about half an hour ago or so. And then gross receipts in 1999, again, refers to total gross accommodation charges for use of the facilities for the room. What's that customer or user paying to use the room? They're paying the same amount, whether they go through the OTC or get it directly. And then if you look at 2010 language, taking rules as they are, again, as I said, it modernized over time. Gross receipts means total gross sales received. Total gross sales received for use of a lodging unit, a single room. So I think they're covered under all of these, but from the very beginning, unit was a single room. Person means more than one person or company, joint venture, unincorporated group, and that's where the liability arises. They never really explained if under the older law, owner-operator always means one person, then they're saying nullify that definition that says groups. They've never explained that, and they don't explain it in the new law in their 68, which says a retailer can have agents and canvassers. I think it's 1568-501. But there's a section about agents and canvassers being liable for any violations of this chapter. The entire chapter of 68. Under their theory, how does that work? If it's always the brick and mortar hotelier that's liable and no one else, then what is this language about agents and canvassers? It's a small provision in a larger code, but it proves the larger point. That, of course, they throw a wide net on any seller, any retailer, any owner-operator, which means a person who rents a lodging unit. And so I think there is harmony across the years on these, but I agree with the premise of the question. We have to take them as they are at the time.
Mr. Krongeier, in light of your argument about the statute of limitations, could you address the argument in the Taxpayers Association brief that if the court reverses, it would expose all businesses providing customer travel services to an obligation to pay uncollected taxes on prior transactions with no recourse to collect from their customers?
Your Honor, the only businesses that have not paid, that we're aware of, the department's aware of, that have not paid taxes on the full amounts they've charged to the users are the defendants in this case. As I pointed out, when a hotel and a travel agent get together and they take in $100 and it's divided 80-20, tax isn't on the 80, it's on the full 100. The whole case amounts to them really telling this court that if the OTC takes in the 100 first and then passes off the 80, somehow that immunizes $20 from taxation. But if the hotel gets the 100 first, okay, in that case it would be on the full amount. That is nonsensical. That is not a reasonable construction, and it doesn't comport with the broad language about the full sales price or full consideration. What one of the questions got to a few minutes ago was about services, and I'm surprised that it was stated again as it was at the district court. Mr. Green said, those words, services, it just didn't get amended out when they amended the services provision of this agreement. But there can be no dispute, we don't tax services in Montana, end quote. Services is used 45 times in the 68 law, 45 times. Direct, indirect, engaging in business. The legislature meant what they said. They didn't need to say it a 46th time. They didn't need to pass a new law in 2007. It's clear on its face as written.
But counsel, and that, I keep getting back to Justice Baker's first initial comment about treating the statutes differently.
Yeah.
We have those provisions in the sales tax, but we have the operator-owner definition in the lodging tax, which does not speak in terms of services.
Well, actually, Your Honor, one point on that. Gross receipts is defined, and I want to read this, as 1987. The gross receipts means total gross accommodation charges for use of the lodging facilities, which again means the room, whether the charges were received in money or otherwise, including all receipts, cash, credits, and properties or services of any kind or nature.
Right, but that argument, we keep going around in circles because we've got the owner-operator requirement for the accommodation charge to begin with under the lodging tax. So I guess I'm seeing a difference between how we handle the two statutes.
Sure. Let me make one last point on that. Let's think about it this way. What they're really saying here is even if you took it as a brick-and-mortar owner-operator and not the definitions that I believe the court should apply that are in the rules, what did the hotel receive in the transaction back in these 87 to 03 years? What they received was $80 in cash, but what did they get from the OTCs? Mr. Green already said the OTCs are helping these hotels market their rooms. They got $20 worth of value of services from the OTC. They got the $100 value in either event, a direct booking or this booking. When they do a direct booking, they get $100 in cash, but they've got to do all the services themselves. When they do an OTC booking, they get $80 in cash, but the OTC has done $20 worth of services. I mean, you've got to come back ultimately to this total and gross amount and full sales price. But let me say one thing on the two laws. I know my time is basically up. There was the sink swim question.
Your time is expired.
Okay, I'm sorry. I'll conclude there, Your Honor, by just saying that we respectfully ask for the same thing achieved in the Wyoming case, which is proper construction of the law and a remand for damages accordingly. Thank you.
Thank you.
Thank you very much to all counsel. We appreciate the briefing and the arguments. We will take this matter under advisement and issue an opinion in due course. I also want, on behalf of the court, to thank both the University of Montana for providing the facility and giving the court the opportunity to be here, as well as Dean Monroe and the School of Law for the opportunity to come over every year for Law Day. It's much appreciated by the court. Thank you very much.